Hello and welcome to Simply inTAXicating. The good news is the GST Council has finally managed to overcome the deadlock over almost much talked about the most contentious issue of cross-empowerment, the dual control, and of course the jurisdictional issues like territorial waters. So GST Council at its last meeting, they managed to reach the consensus with a decent note of course coming from a couple of finance ministers. The important issue is the center and the states are going ahead with the GST. The GST model laws were already approved. It is going to be legally vetted and finally presented before the GST Council. But the critical issues which we need to discuss today and look into it from the trade and industry perspective, how exactly this 90-10 ratio, 90-10 for below 1.5 crore threshold, 10% will go to the center and 90 to the states. So far as audit is concerned, in case of anti-evasion, it's uniform for the entire chain of tax base, assessee base, for the center and the states both. So now the issue is the good number of officers from the CBEC field formation side. They are looking at this 10% as a kind of, they have lost the game, which may not be the case. So we are going to look into all these aspects, how exactly this is going to work, how well is going to be the rollout of the GST, with the Honorable Finance Minister announced that this is going to be 1st July. Maybe it can be further postponed. It depends on the preparation, the kind of preparation and the feedback from the industry and trade. So we have 4 distinguished domain experts with us. We have Mr. Sumit Dutt Majumder, the former Chairman, Central Board of Excise and Customs. We have Mr. Shashank Priya, the Joint Secretary, the GST Council. We have Mr. Pratik Jain, the National Leader Indirect Taxes, PwC, our knowledge partner also. And we have Mr. Rustagi, the former Joint Secretary TIOL and the former Chief Commissioner of Customs and a very well-known domain expert. So welcome, sir. Let me start with Mr. Majumder. Sir, please tell me, this one input which we have been receiving with respect to this cross-empowerment where this 90-10 ratio with the GST Council finally managed to arrive at is not being welcome in the field formations, where the CBEC officers particularly, but otherwise for trade industry, perhaps this could be a welcome. I will go back to Pratik and sir to find out, whether they are really welcoming it or they look at from a different perspective.
If you have a look at the progress of negotiations in reaching the GST, we find that Union Government, Finance Minister, has made number of compromises from the very beginning. First of all, petroleum and petroleum products were out, alcohol was out, even the elbow room was given to the states to vary the tax, which was not very welcome by the trade. They want uniform taxation everywhere. Even on that, states demand is compromised. Compensation, 5 years, 100%, that also is compromised. So, but then I have been maintaining that these are necessary compromises in the spirit of cooperative federalism and in order to get everybody on board on the GST. After all, it is a joint venture. And a joint venture, the 2 partners must be happy. So that's why it was done. So I have been maintaining that. But unfortunately, this compromise, I won't say it compromise, it is a policy of appeasement. And appeasement has never succeeded anywhere, at least to that extent. Now you see, this I come to this 1.5 crore. The center's original proposal was very good. That okay, you do its vertical split and then less than 1.5 lakh give us the services. Why? Because the central officers, the officers of the CBEC have the collective experience of more than 22 years in taxing the services. And you will appreciate that taxing the services is different from taxing the goods. The services are intangible. Those are goods are tangible. Right. And now you are taking, and then 93% of the service tax assessees of the center will now go out because they are below 1.5 crore. And you are giving these assessees to the states who have no experience whatsoever in taxing the services, and particularly the place of determination of place of service rules, and all those things will create a lot of problem. CBEC officers it's not a matter of turf war. It's a matter of the decision that the collective experience of 22 years are just ignored and given a go by. If you go by the record, the evasion of cases, number of evasion cases that the DGCI has detected, maximum is in that 1.5 crore less than. So this is one. Secondly, audit is the essence of GST. I always quote Professor Richard Bird in this regard. And he said that After GST comes, the excise officers will cease to be an excise officer, they will become an audit officer. Now, in audit, okay, you have earmarked 5% for the audit. Now, actually, the center CBEC officers will be doing audit of 5% of 10%. So, the maximum, main thing of auditing is gone. I go back to the point that I had made, that it is a joint venture between center and states. And you can't make one partner unhappy. Right now, the field formation officers of the center are very unhappy.
So, Pratik, from the trade perspective, how do you look at it? This issue, of course.
So, I think trade overall is happy that you've got one authority to deal with them. Okay, and that's what they wanted. Now, the point on that, that yes, for services sector, the center was doing it for 22 years, a very valid point, and this is complex. But then states could have the same point against center, that for many years, the center does not have experience to manage sale of goods. Right, the sale of goods is completely with the state since independence. Right, so I think service sector is a little concerned right now, because let's say a large telecom company with registration in 30 states, half of them might be audited by center, half of them might be audited by state, and that's not a happy situation. Their demand for centralized registration also, it seems, is being denied, and is not being met. Yes. Perhaps it might be better in services sector to still think that very complex sectors like banking, telecom, real estate, etc. Few of them are given to the center, at least to start with, for 2-3 years. Particularly services where they have multiple presence. Now, industry, to my mind, I am not too worried about below 1.5 crore service providers, because those will be largely local service providers like restaurants, etc., etc. So even if states do not have enough experience to audit them, they can learn. Real problem is the large service sector like banking, insurance and telecom, where it seems that administration would be a problem. But overall, if there is only one authority, I think industry and trade generally is happy.
So how do you look at it, sir? Mr. Majumder suggested that, the central excise officers are going to be the audit.
I agree with him that it was a long road actually, this GST, and so many people have to play a role. Economists played a role in theorizing that GST is a good tax and you should adopt it. Politicians have to play a role, tax administrators have to play a role, state and center have to play a role, trade industry have to play a role. So overall it has to be a compromise model anyway.
Right.
And it depends that who ultimately has the say in it. Who has to give a decision that yes, I compromise this much, I do not compromise this much. So far in the council, it has been debated, but it has not been voted. None of the points has been voted.
Yes, right.
And I think the finance minister was very conscious that we should not lay a precedent of voting in the GST Council. So he has been very conscious of that fact, and that is why he has struggled very hard that as far as possible we should take decisions by consensus. And when you take decision by consensus, then some compromise is unavoidable. There is no way you can avoid compromises. There have to be winners and gainers, and there have to be losers in this compromise. So it depends how you see the whole picture. If you see the picture of the center, one may have a perception that yes, the center has lost in the sense that so far as this 1.5 crore threshold assessees are concerned,
right,
you are losing a lot. And there is no economic rationale that it should be 90 or 10.
10, right.
Economics rationale could have been that it should have been 50-50 all through. If you are having a ratio of 50-50 in the other areas, then why it should be 90-10 in one area only? So that does not make much sense from the decision point of view. But I think ultimately it had to be compromised. There is no way for a finance minister, because the deadline is also there that you cannot go beyond 16th of September anyway.
Right, sir.
And people have to be given a signal that it is coming, and you have to tell them yes, it is going to come. So suppose you go on deliberating it till April, then people lose confidence that it may not come.
Right, sir.
So that is why I think all these factors are counted. There are some losers, there are some winners in this.
Right,
Yes.
sir. So let me go back to GST Council. Sir, I mean, Mr. Rustagi made a very valid point. Is it a deliberate decision? Is it a very well deliberated decision of the GST Council chairman not to resort to voting and continue with the consensus spirit within the proceedings of the council? So how exactly this is a kind of miracle. I mean we have dozens of politicians and no politics.
What Mr. Rustagi said is spot on. In fact, it's very interesting that though he has not been part of the proceedings, but he has articulated what the Honorable Finance Minister has been saying in the council proceedings, that this is a body where we have to set conventions. This is the body which is very unique in its nature in the independent India. It is a body where for the first time there is a collective sovereignty is devolved of the center and the states. And he has been emphasizing again and again that the only way that it will work in a very constructive manner is that we work in a consensual manner. We do not resort to voting. And that is the reason why, as Mr. Rustagi said, that issues are being discussed, rediscussed, revisited, till we try and reach a consensus. And this is what has happened on all the issues. And this is what has happened on this dual control issue, which started right from the first meeting and it took the 9th meeting to come to a conclusion. So that is a very, very conscious decision that this body should set a very healthy convention of deciding by consensus, though there is a provision for voting.
Right. So now, sir, let me take up this territorial water issue, this jurisdiction, which has been a bone of contention right from the beginning. The states have been demanding jurisdiction over the territorial waters. How do you look at this, Pratik?
So I think there is a lot of litigation which is already there. There are two issues to my mind. One is what happens if the goods move from within 12 nautical miles to a place which is outside 12 nautical miles. Right. So let's say Mumbai High, etc. Now the issue there was that let's say if goods are moving from Maharashtra, assuming it 12 nautical miles, it extends to up to Maharashtra territory, to Mumbai High, which is beyond 12 nautical miles. Does the state of Maharashtra have a right to levy tax on that?
Okay.
Or is it export? So I think now the decision of the court is that it cannot be export because there is no identified territory to which it is going. So if it is not export, then the question is it a local sale or is it an interstate sale? It may not be interstate sale because again there is no territory, there is no state there.
Right.
So that litigation is already pending in the Supreme Court. And that I think, perhaps will continue. Even my understanding is that now the agreement is that up to 12 nautical miles, the state will have right to levy tax.
Right.
Which happens today as well in some sense. So
exactly.
That has been resolved. What has perhaps not been resolved and that will come through courts is what happens, the transaction happens from within 12 nautical mile to a place which is outside. Because outside 12 nautical mile today, excise and customs are applicable, right, on those places. But there is no clarity on that. So state GST, whether it will apply or not, that I think issues still need to be resolved. But I also wanted to understand this in a little more detail as to what was the state's concern on this and how it has been now, it is proposed to be addressed.
Before that, sir, I'd like to go to Mr. Rustagi. Sir, what used to happen earlier? I mean, this kind of dispute must be there in the past also, and this kind of practices are not something new. I mean, we have been, high sea sales are there with respect to customs. Earlier also, so now we have exclusive economic zone, we have different kind of territories. So what has been your experience with respect to territorial waters? So the taxation within those?
Earlier, I think it was, mainly confined to custom duty. It was not so much of the countervailing duty or other duties. So probably for the first time it is being tried that so far as these goods which will be imported into India, how it should be taxed. For the first time, I think. Earlier it was center's domain basically. If it is outside the territory, within the territorial water. So it was basically, central government's domain and they were collecting the tax anyway. But now I think the states want that this revenue should accrue to them. So it is in that spirit that they have asked for it and the center has agreed to it. But purely from a taxing point of view, it should not create much of practical problems, I think. Whether it is center or the state, I do not see much of a problem in.
Right, sir. So how do you look at it, sir? I mean, this territorial water jurisdiction being conceded to the states by the central
No,
government.
I think so far as I recollect, I think it was restricted to Andhra Pradesh to start with, and an exception was made in the case of Andhra Pradesh government, where the bunkers supply within the territorial
Yes,
water,
sir.
they are collecting taxes
Right.
on sale, and I believe the revenue is about 600 crores.
600, right.
And now the other states also say that now that they are finding that the things are going away, so some more thing. So again, as Pratik has mentioned, the certain cases are in the Supreme Court. What will happen if the Supreme Court judgment comes contra to what the decision the GST Council takes?
Right.
So whether GST, because the Supreme Court decisions will be in the context of the law as it was existing at that time. So if you are empowering them, then you need a legislation also for
Right,
that.
sir.
So I
Right,
think that is my understanding of things. If this center, again as a matter of compromise and bargaining, gives that power to the states, then it will have to be through a legislative process.
Legislative process. Now, sir, you give us the perspective what happened and what exactly is the correct meaning of the decision, because it is being speculated. Little gray area exists even today. So what happens? What has been decided?
The issue, as Pratik mentioned, territorial water, and as Mr. Dutt Majumder also said, that traditionally one aspect is that states have been enjoying certain powers in the territorial waters. Rights of fishing in the territorial water are given in the constitution itself to the states. Certain rights have been, or certain responsibilities have been entrusted to them over a period of time, like coastal security. Taxation, the fields of taxation were different. VAT, constitutionally only states would levy, and they have traditionally for last, since independence, have been levying VAT on transactions that are taking place within the territorial water. The issue that was deliberated is, should you now have a legal recognition of the fact that this is part of the territory of state, the coastal water? And there it was, after deliberation, it was recognized that a decision should not be arrived at which is contrary to the constitution, because as per constitutional provisions, territorial waters are part of the union territory, because the schedule 1 of the constitution, when it defines states, it does not take into account the territorial waters. Right. So that is one part, is that it is not being legally conceded that union territory is part of the state.
Okay.
But also having recognized the fact that states have been collecting revenue and there are substantial revenues involved in the state on state component of the taxes, it has been now decided, agreed in the council, that some mechanism will be found by which states will be empowered to collect taxes which are of the state, in the nature of state levy, but without giving them the status that they are part of the territory of the state.
Okay. So it's basically going to be IGST.
It would be a certain deeming provision shall be worked out,
Right.
to say that this maybe the place of supply would be treated as within that state, so that it can be regarded as an intrastate supply and SGST can be collected on that. Okay. Like your SEZ.
Yes, absolutely.
We are saying it is interstate supply,
Right.
though this is part of the territory of the state. So it can be the reverse here.
Right.
By way of a legal fiction can be done, but not to alter the definition of the territorial water as it is in the constitution.
So, I think up to 12 nautical miles, I think is clear. What is not clear to me is that if the state boundary extends up to 12 nautical miles, what happens if the transaction takes place from that state to a exclusive economic zone?
Right.
That transaction, will that be taxed or not? That
if it is not exported, then what will be the status, the legal nature of that transaction? So what will happen? So is it
if the goods go from Maharashtra, which is, let's say, beyond with Maharashtra landmass, let's say, to a place which is outside 12 nautical miles, but within 200 nautical miles.
Right.
Then, and there is a consideration for that. Then, is this export? Is this liable? Is this IGST? Is it that aspect? I think is still
that's a grey area.
But today, who is collecting after 12 nautical miles? If any sale takes place after 12 nautical miles, who is collecting?
If the sale takes place from the state and the goods go beyond 12 nautical miles, then that is precisely the issue which is pending the Supreme Court today. States are saying that they can collect tax on that. assessee is saying that no, it should either
They
qualify
will
as
take a view.
or it should
They will
qualify as
take
a
a view when
transaction
it comes to that.
which is not liable to VAT.
They will
And that
take a
is
view
issue
at
is
that
pending.
time.
The center has not been for
Because
years.
this,
Yes, of Andhra Pradesh.
I think this GST Council is a living creature. It will continue.
Yes.
So if the problems arise, certainly they will take stock of all the issues which are arising even after the introduction of GST. They will take a view on that.
They will, sir. But now, important question is now in this decision, the coastal states will gain. What about the landlocked?
But they are going to be compensated for 5 years of the center, so that's not a problem.
After 5 years? Beyond 5 years? A state like, let's say, for instance, Bihar, for instance, it's a landlocked. A state like Haryana, for instance, or maybe Delhi, for instance.
But they will gain when it is consumed in their area in any case.
Tax bonds should be there.
But this is not a case of, sir, unjust enrichment. Certain states are being appeased.
No, ultimately GST.
So the center is losing its territory.
Ultimately, it is a consumption tax. Suppose even if a sale of a merchandise takes place outside within the territorial waters, and the goods are consumed in Bihar, so Bihar will gain at that stage in any case.
Right, sir. But this 42% from the divisible pool, sir, we are ignoring that. Ultimately, the revenue, they are going to get a share in the 42% also. So, there the landlocked states will lose. So, from that perspective.
Maybe you can look at it from both perspectives. One is that perspective. Second is if we had changed the present practice of territorial, of coastal state collecting taxes, and we would have started following a new system, it would have led to unjust impoverishment of the coastal state. They are today collecting those revenues and now it would go into the divisible pool. So that was their concern, that at least the state component of the tax which they have been collecting, they should continue to collect.
So it's a status quo.
It is the status quo.
This cross empowerment, so I think this under IGST, to what extent or how exactly this is going to work?
Mr. Dutt Majumder talked about cross empowerment for the CGST and SGST. It is the decision in the council is that similar principle will apply for taxpayers who are also doing interstate supply, because those who are doing interstate supply would also in all probability will be doing intrastate supply. So the same system of cross empowerment will apply, except it was recognized that there can be certain situations which can be situations of conflict of interest between two states.
Right.
And that was recognized would be largely in the issues relating to place of supply. So in the cross empowerment for IGST, it has been decided that there will be one carve out, and that is for place of supply related disputes. Adjudications will only be done by the central tax authorities.
No, it's very important because I know that we have been working with many companies, and particularly for banking and insurance, place of supply is a big concern. A bank, should I pay tax where my branches are? Should I pay tax at the head office? How should I pay tax? But the place of supply is clear. That place of supply is a place where my customer is located. That is fine. But where do I pay tax from? That itself is a big issue. So
right. So you think the CBEC should be a little happy, sir? I mean, from this perspective.
You are making it as if it's a turf war between CBEC
No, not at all. Sir, but for the time being, yes.
I'm having a very neutral view. So on the IGS, you see that I have my views that Article 269A read with 246A in the Constitution very clearly says that center will levy and collect IGST. Okay. In contra this, you remember this CST. CST, it was there, center will levy but assign the job of collection to the states. Right. That is not there. Right. So now I don't know how you will cross empower in the case of IGST. I thought IGST, it is the exclusive authority, also Constitution authorizes the center alone. So this is the first point. Second point I want to make is that this, again I come back to the audit. Audit is the essence of GST. Please don't restrict the center to audit. You restrict 5%, but don't make it 5% of 10%. That I have very strong reservation. Then the whole thing of GST is standing on a few things. One is that seamless flow of credit. One is that IGST interest and the consent of supply, and then audit. Now here, if you restrict the central officer, so audit and activation, you should there should not be any restriction. Whatever is there, 5% will be there. I'm not saying that same company should be audited by center and state both.
I get
No,
the point.
not
One
that.
assessee, one authority.
Absolutely.
Right.
That
should
I'll
be the
maintain.
principle
That I'll maintain.
guiding
I think central government had a view earlier that why do you want to split 100% assessees into center and state? Don't do that. Only select 5-10% of those people who are going to get audited and then split that between center and state, which I think was not practical because there are issues of anti-evasion, there are issues of clarification that if I have to, as a business, I have to seek a clarification, where do I go? So I think they have worked out a compromise. But I heard Finance Minister saying that there would be a specific provision perhaps in the IGST Act now, which empowers the state government also to administer. Now, to Sir's point that Constitutional Amendment Bill now talks about levy and collection both, and CST Act. I have not examined that, but I'm sure that there is a view of Attorney General which has been taken on this, because the first view of the Law Ministry was that you can't do it. Right. But after that, in the next GST Council meeting, we have agreed to do that. And we also heard that it has gone to Attorney General for his view. So I would be surprised if there is a view which has been taken without proper consultation on that. Because if there is a constitutional embargo, then by making an amendment in the IGST Act, you won't be able to do it.
It will be ultra bad. Yes, correct.
But some law ministry people are also in the council, is it? No.
No, they are not in the council. But the basic question is that, what Mr. Dutt Majumder said, that 269A talks about levy and collection.
Right.
It shall be with the central government. And states have been consistently pointing out that the same language has been used in Article 269. It will be, the levy and collection will be by the center, and what will be assigned is the taxes will be assigned to the states.
Right.
So they say there is sufficient precedent in regard to allowing the state to collect, and failing that, there is Article 258, which also says that center can entrust its function to the states subject to the approval by the Honorable President of India. So there are precedents, there are legal provisions. So keeping all this in mind and taking note of the very strong concerns that states had, and also the fact that, it's a reality that you have to provide for a mechanism of single interface. So taking all this into account, this has been decided.
Section talks about levy and collection. And collection is still being done by center, okay, or IGST. What is being done is only the administration, which I think as a delegated power they can give. So because the collection of IGST will still be happening by the central government. So there's no conflict there. The question is that if levy and collection is with the center, can the administration or audit can be given to the state or not? And maybe the answer to that is yes, because it's not a collection that is being given to the state.
But then we have to read the previous constitution provision with regard to the central assessee is assigned to assigned to states. That is not there in the current 269.
Assigned word has to be so qualified.
Not there. So legally
the word assigned has been now replaced by the word apportioned. Because
yes.
Earlier the entire tax was being given to state, now a portion of the tax is going to the state. So that's why the wordings have been different.
Between the center and the state, yes. So on this note, let me thank my guests first and wind up this debate. And quite a few interesting clarification has come from how exactly this GST Council has decided the issues, territorial water issues, IGST, cross empowerment, and of course the audit side. And of course, I mean, as Mr. Majumder suggested, that maybe the center could or GST Council could take a look at it, that they could be allowed not 5% or 10%, perhaps the number could be bigger, but one has to certainly look at this, how well equipped the commissionerates are to deal with that kind of large number of assessees. Another important point from which Pratik raised from that the central registration point, which continues to be a major point of distress so far as all those concerns which are doing all India businesses like banks, telecom, insurance, non-banking financial companies, etc. So maybe it will be a difficult time for them going ahead, the GST. And as Mr. Rustagi suggested, that ultimately it's a compromise, and compromise means some of them are winners, some of them are losers, but not necessarily the CBEC or the center is a loser. Mr. Rustagi rightly suggested that the entire tax administration is going to be IT driven. It's going to be a kind of faceless interaction so far as taxman and the taxpayer is concerned, and there would be a GST network is going to play the most critical role and going to be the ultimate custodian of the interest of the exchequer. So looking at all these dimensions, let me once again thank my guests for giving us very valuable insight into these issues and the row ahead. There will be many more rows which are still pending. before the GST Council. Thanking you all for watching TIOL.